All right. I think we got it all covered today. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentations of Eviction, Knowing Your Rights. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. In addition to that, we have our presenting partner with Lone Star Legal Aid. We have Ms. Sapna Ayers, and I know you see Kimberly DK there, and she's typically one of our regular presenters, but we have Ms. Sapna Ayers filling in today on behalf of Lone Star Legal Aid. Again, she will be presenting the information for you today about evictions. But first, I want to make sure that we introduce the other partners who are also included in the A Month of Service is the Earl Carl Institute, the Houston Bar Association, Houston Volunteer Lawyers, Texas Legal Services Center, Harris Central Appraisal District, and the Harris County Texas Assessor Collector's Office. And together we make up A Month of Service. And basically what A Month of Service is, it's the collaboration of all of our organizations. We come together on a monthly basis, offering a variety of different workshops, resources and information to the community relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that either don't have access to a lot of information or don't know where to go for any kind of assistance, specifically for a lot of civil legal assistance that is available to them at no charge or at very low cost. So we ask that if you all know of anyone that is facing eviction or need some information about eviction or any of our other presentations, that you pay it forward and certainly pass the information along to others. This is your opportunity to ask whatever questions that it is that you have in regards to our topic of today, which is evictions and knowing your rights. However, we do want you to try to keep your questions to be as general as you possibly can, as we are on a public platform, as well as we are recording and broadcasting live on social media, on Facebook and on YouTube. So we want to try to protect your privacy as much as we possibly can and not have your personal detail information getting out there for everybody to actually have access to. So if you are joining us on Zoom, please feel free to type your question into the chat and we'll make sure that it gets read aloud at the end. If you are joining us on Facebook or on YouTube, then please write your comment and your questions into the comment section, and we'll make sure that it is, again, read aloud at the end. And I know that as some people registered, they emailed a couple of questions in or a couple of comments, and I'll go over those at the end of the presentation as well. So also note that the information that is presented here today is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourselves in need of civil legal assistance. We want you to know that there are income qualifications. However, we don't want you to automatically discount yourself and automatically assume that you won't qualify for their service. So please reach out to someone because, eviction is serious, foreclosure is serious, and we don't want you guys to end up in a situation or where you're waiting to the last minute to try to get some kind of assistance to try to help save your housing or your home. So again, we want to thank you guys for all joining us for today. If you're new, welcome to A Month of Service presentation. If you've returning, thank you for your support of this collaboration. And we hope that you all received the information that you came to get today. So without further ado, we're going to go ahead into our introductions and then we will get into the presentation. So Ms. Cecile, would you like to introduce yourself?
Thank you so much, Nia. My name is Cecile Carlson. I'm an outreach coordinator here at the Department of Neighborhoods. And I want to welcome everybody to today's workshop and also thank our partners for this incredible collaboration. This information is important and it's information that we often can Google and try and find it, but you're never sure if it's applicable to you or if it's even, applicable to the place that you live. So very thankful to be able to hear it from the experts. And again, I want to welcome everybody and on behalf of the Department of Neighborhoods, our Director Sims, and of course, On behalf of Mayor Whitmire, just want to thank everybody for being here and also thank the partnership. I'll go ahead and pass it over. Thank you.
All right. We have Ms. Sapna Ayers. Go
Hey,
ahead.
everybody. Oh, sorry, Nia. I'm Sapna Iyer. I'm a directing attorney with Lone Star Legal Aid, and I supervise our Houston units, including the eviction right to counsel. I am covering for two of our attorneys today who are actually in court. And so in a few minutes here, we'll get started and walk you through some basics of some landlord-tenant law.
Okay. All right. Well, we can move right on into the presentation, Sapna. Go right ahead.
Okay. Okay. So as Nia said, I just want to reiterate, this is an informational session only. Nothing you're going to hear today is to be construed as any type of attorney-client relationship. So the presentation is a Know Your Rights on evictions. Kim and Ben are actually in trial, so I am covering. My name is Sapna Iyer. Okay, so this is just a little bit of background on our program. We're a nonprofit law firm. We began with the Houston Legal Aid Clinic in 1948 and merged with East Texas Legal Services in 1977. There's a couple of ways to apply for us. The link down at the bottom of the slide is the easiest way. You can apply 24 hours a day, 7 days a week. You can also call our main number, which is 713-652-0077. It'll be on the slide at the end, and that'll take you to our centralized intake line. But the apply here link shown at the bottom of the screen is the easiest way to get to us. So this is the agenda today. We're going to talk about leases, terminating your lease, a notice to vacate, the eviction suit, how to appeal that, some special provisions that apply to public housing and subsidized housing. We'll talk about lockouts where the landlord locks you out of the apartment, and utility shut off where the landlord cuts off your utilities. And we'll also talk about security deposits. Okay, so your lease. Texas allows for verbal and oral leases. The lease is the agreement between you and your landlord. It is governed by TPC 92001. TPC stands for the Texas Property Code. And we're going to have the different statutes listed just in case you feel like pulling up the code and reading it. If your lease is for longer than a year, then the lease has to be in writing, and your lease is a contract. Just like any other contract that you sign, it will very specifically say what you can and cannot do and what your landlord can and cannot do and what both of your obligations are to each other. You have the right to get a copy of your lease. And within 3 days of signing the lease, the landlord should give you one. If you didn't get a copy of your lease, ask for a copy of your lease in writing. Typically, most landlord-tenant relationships, the documents, all of those things have moved on to portals of some sort. So it might be that your lease, the fully executed lease, is in your landlord-tenant portal. So you might want to check there if you haven't actually gotten a copy of it. Okay. Know your lease terms. Read over your lease and make note of important clauses. So monthly rent, when and where to make payments. Typically, again, if you're in any kind of portal, the rent is going to have to be paid through your tenant portal. Sometimes the rent is due in the management office, so make sure you read through the lease and see when you're going to have to do that. It will let you know when they're going to charge late fees, whether or not they're going to charge you fees for insufficient funds. It'll tell you how payment applies. Most leases have a little bit of a grace period where even though rent is due on the 1st, they don't charge you late fees until the 3rd. I want to make sure I say that again. It's due on the 1st, but they don't charge you late fees until the 3rd. That doesn't mean your rent is due on the 3rd. Your rent is still due on the 1st. So make sure you read that carefully. And then also how payments are applied. So most leases have some sort of what they call a priority of payment, where they will charge any fees, any fines, any penalties, and that is what will get paid first. And then they will apply your payment to the rent. This is a lot of times how people fall behind. Let's suppose the rent is $800. You pay $800, but you had a $30 late fee from last month. Well, what's going to happen is they're going to take that $30 out first, which means you didn't actually pay all of the rent, and now you are technically behind on your rent. The initial lease term, typically a year, although more and more landlords are offering 2-year leases or 18-month leases. Once your lease is over, a lot of times your tenancy changes to month to month. It is also not uncommon that your month to month rent is more than if you had actually had a signed lease agreement for a year or 18 months or 2 years. There are community rules and policies. These are going to be things like when you have to take your trash out, where you can put it, parking rules, whether you have to have a parking permit. It'll have policies on gas. There'll be policies on smoking and drug use. It's probably a bed bug policy of some sort. There's going to be addendums for HUD and HHA. These are typical housing. There's going to be concessions, right? So is your landlord going to come by and pick up your trash if you put it outside every once a week? Is there Wi-Fi? Is it all bills paid? Those kinds of things. There are very specific acts of default. If you don't pay your rent, that is the biggest one. Material breaches. So these can be things like fighting with your neighbor, violence on your property. These are going to be things that are material breaches. Early termination or holding over. So if you break your lease and you try to leave early, holding over is if you stay past when your lease is over and you're not in a month-to-month tenancy. Those are defaults. Timelines, notice of a lease renewal or non-renewal. Most leases will say if you're going to renew or non-renew, you have to give 30 days notice or 60 days notice. You need to check your lease to see what that is. Notice to vacate, we'll talk about that a little bit more, and notice of defaults. Terminating the lease. So after the initial lease term, both parties have the right to terminate the lease as long as you follow the notice guidelines that are in your lease. So typically, if you're going to leave at the end of your term, for whatever reason, you have to give your landlord notice. You have to say, I'm not going to renew. And typically you have to give them that in writing, again, 30 or 60 days before your lease ends. You need to check your lease to see what that date is. If you don't leave when your lease is over, you're a holdover. You are there without any legal right to be there. And except in very special circumstances, you cannot make your landlord renew your lease. Just like your landlord cannot make you renew your lease. We get calls sometimes where people say, well, my landlord won't let me stay here and my lease is ending. Unfortunately, except in very special circumstances, your landlord doesn't have to let you stay there. This is a contract. It's a contract for a very specific term, a year or 18 months or 2 years. And when that term is over, you have to enter a new contract or you have to leave. And again, the flip side of this is your landlord cannot make you stay there. Whether or not you are allowed to stay in your rental unit is an agreement between yourself and your landlord. Terminating the lease during the initial term, so that's during that signed contract period, is an early termination of your lease. There are typically fines and fees and penalties if you terminate your lease without consent, meaning your landlord does not let you out of the lease. So if you just leave, there are going to be penalties and fees that your landlord has the right to charge you, and these penalties and fees are spelled out in your lease agreement. Rights to early termination. There are very specific circumstances where you do have the right to break your lease. So for where you can break your lease and leave. Typically, in those 2 instances, there is some sort of family violence where the tenant, the person living there, is facing some sort of violence from the landlord. And I'm sorry, I just got a notice my internet is unstable, so I'm going to stop my video and hopefully that will help. Okay. So the tenant's death, it avoids future liability. Past due obligations, unpaid rent, damage beyond wear and tear are still recoverable by the landlord. So if your tenant dies, the landlord still has the right to go after the tenant's estate for things that happened before the tenant died. Certain things related to military service, you can waive this right. Typically, these involve protections, like if you're deployed overseas for a certain amount of time. Let's suppose you have a 1-year deployment. It really makes no sense that you're going to be in a lease that you aren't going to be living in because you've been deployed. But again, make sure that if you are trying to break your lease early because of these events, that you pull these property code sections. They are available on the internet. There is actually the Texas legislature. All of the statutes are available online. So you can put in the Texas property code and you can look at these provisions. Other rights to early termination, casualty loss. This is a big one here in the Houston-Harris County area. If the premise is made totally unusable due to a casualty loss and the loss is not the result of a tenant's fault or negligence, the tenant has the right to terminate the lease. So where we see this the most common example is a hurricane. A hurricane comes through, totals the apartment complex, the landlord has insurance, the tenant has the right to break the lease. Landlord cannot make somebody stay there in an uninhabitable complex when it wasn't their fault and when it's not livable. The landlord also has the right to terminate the lease if the property is unusable. If the premises are partly unusable due to a casualty loss, and again, it's not the tenant's fault, the tenant can file a lawsuit in certain courts and try to get the rent reduced. Now, the statute does not say the landlord has to reduce the rent. It says the tenant has to file a lawsuit. Sometimes the landlord will work with you. That's just something you should bring up with them if this is something that you're trying to do. The landlord does not have the right to terminate the lease just because the premise is partially unusable. We do see this sometimes, unfortunately, where landlords will try to kick people out because there is some damage. But if the apartment or the home, whatever the rental unit is still usable, the landlord does not have the right to kick you out. You can change this provision if the lease says differently. So again, we put the statutes in here for you to review if this is something that you're looking at. Make sure you review them carefully. The property code is one of those things where you kind of have to follow it to the letter. Termination of the lease due to a breach. So a breach basically means somebody has broken the terms of the contract. Any violation of the lease terms, conditions, rules, or other provisions, and your lease will tell you what those things are. Common provisions: when the resident breaks terms in the lease, the biggest one is failure to pay rent. Paying rent late is also a default. Repeated violation of community policies. So if you're in a non-smoking complex and smoking is not allowed anywhere and you smoke, if there is violence of some sort, those are violations of the community policies. Unauthorized tenants. If somebody is living with you and they are not on the lease, that is an unauthorized tenant. If you have criminal activity by your tenant, occupant, or guest, the landlord can hold you responsible for that. If you stay in your apartment after your lease is over, if you're holding over, the landlord can hold you responsible for that. Before the landlord can try to evict you, they have to give you proper notice. Withholding rent. We hear this one a lot too. Well, I have roaches, I have rats, I have bed bugs. You know, my landlord never comes by to pick up the trash, even though I pay for that service. You know, I pay for parking, but I never have a parking spot, so I just didn't pay my rent. Do not do that. Never withhold your rent. In Texas, you are required to pay your rent in full and on time when it becomes due. If you do not pay your rent, the landlord can evict you for not paying your rent. And in Texas, this is the big one, In order to have any rights, you must be current on your rent. So once you fall behind on your rent, even if you are withholding your rent, your landlord doesn't have to repair your complex, repair your apartment. So if the reason you're withholding your rent is because you have damage to your apartment and the landlord refuses to fix it, once you withhold your rent, not only does the landlord not have to fix it, now the landlord can evict you. So if you're having issues obtaining repairs, you want to check out the property code 92056. You have to send your landlord a request in writing by certified mail. And we put on here to contact a legal professional. This is actually a much more tricky step than you would think that it is. So if you take nothing else away from this presentation, do not withhold your rent. Always pay your rent, because if you don't pay your rent in Texas, you have no rights. Special cases. What if you try to pay your rent and the rent is refused? So the landlord is not free to refuse your rent just because they feel like it. If you have a valid lease agreement and you're paying on time and in full, the landlord is required under that lease agreement to take your rent, right? You agreed to pay rent, the landlord agreed to take it. So rents can refuse to take rent if it's late, if you're only making a partial payment, or if the lease has been terminated. And landlords can determine the manner of how you pay your rent. So whether that's going onto a portal and paying your rent that way, whether that's requiring a money order because past checks have bounced, they can do that as well, but they still have to take your rent. So if you have tried to pay your rent on time and in full, and the landlord has refused, these are some certain steps that you can take. Look at your lease, look at your ledger, and see if what you're offering to pay is really what you owe. Because if you have fees and fines, remember I talked about earlier, the landlord can deduct those amounts from your rent first. And so you might actually owe the $800 in rent plus $30 in fees to become current, not just the $800. Document the date and the manner of the payment. Document correspondence with the landlord. Keep the payments available and do not spend them. Put them in an account somewhere, put them into your mattress, put them wherever you put them to save them, but do not spend them. Continue to offer rent in full and on time. Some other tips are to record yourself on your phone trying to pay the rent. One other thing we ask people to do is send the rent in by certified mail, return receipt requested, make the landlord refuse it and send it back. So you have proof that you have been trying to pay the rent and the landlord keeps refusing it. And then also the big one, of course, is to contact an attorney. Notice to vacate. Before your landlord can evict you, they have to give you a notice to vacate, and it has to be proper and it has to be written notice. This is the property code section that covers that, 24005. The notice has to be in writing and has to give 3 days of notice unless the lease allows for a shorter period. So again, double check your lease. Most of them require 3 days, but it can be as short as 1. Proper delivery, in person, so hand delivered. When they hand deliver it, it has to be to someone who is over the age of 16 and actually lives in the complex. They can't give it to your neighbor. They can't give it to a friend. They can't give it to your kid who's 12. They have to give it to you or your significant other or an almost adult child living in the unit. They can send it regular mail, registered mail, or certified mail, and they can post it to the inside of the front door. Okay, they can't fold it up and shove it in between your screen door and your outer door, or kind of slap it on the counter so it may or may not be on the counter when you get there. Posted to the inside of the front door means it is literally taped on the inside of the door. So when you open your front door and then you shut the front door, you will see the notice to vacate taped to your front door. As an alternative, they can affix it to the outside of the front door. And if that's where it is, take a picture of it because it has to be in an envelope. The landlord has to prove that that's what they did, and the landlord also has to mail you a copy before 5 p.m. on the same day. So if they put it on the outside of your door, they have to also mail it to you. And again, outside of the door does not mean I shoved it in between the storm door and the outside of the door, or I rolled it up and shoved it in the door handle. It means it is taped in an envelope to the outside of your door. The CARES Act. So the CARES Act is part of the COVID Relief Act that was passed. Most of those provisions have expired, but this particular one has not. Under the CARES Act, if you are a covered property, landlords are required to give you a 30-day notice to vacate. So generally speaking, being a covered property means that there is federal money involved. Somewhere, somehow, this complex is getting federal money. So Violence Against Women's Act, it's called VAWA, that's one way. Public housing, Section 8 housing, if you have project-based housing, low-income tax credit housing, there are a whole bunch of federal programs. So if you have a federal program of some sort helping you pay your rent or giving you some sort of reduced rent, then they have to give you 30 days notice. If the landlord has a mortgage, and a lot of apartment complexes do, right? They had to borrow money from a bank to build the complex and rent it out, and they pay the mortgage back every month. And it's a federally backed mortgage. So if it's a Fannie Mae mortgage, a Freddie Mac mortgage, an FHA or a VA loan, they also have to give you 30 days notice. And it includes single family homes, duplexes, mobile homes. For large properties, there are some databases that are available for a search that will tell you if it's a federally backed mortgage of some sort, but they're not all updated. The best way is to check the property records in your county and look for the actual property itself and see if it has in there, if it's a federal loan. All right, evictions. This is covered under the Property Code, Chapter 24. It is the right to deal with possession of the property. So the point of the eviction is to determine who actually gets the property, the tenant or the landlord. There are main elements the plaintiff has to prove, and the plaintiff is going to be the landlord when we're talking about evictions in this scenario. The landlord has to prove they're the owner. So it's actually not as simple as you would think. Corporations that own apartment complexes, it might be sold to another complex. They might have a name change. They might have documents that aren't filed with the state. So let's suppose the corporation is a corporation from Delaware. Well, there's things that that corporation has to file in order to be able to prove that they own this complex. And so this is kind of a technical legal place, but they have to prove ownership. Breach of the lease or termination at the end of the lease. So breach of the lease, the biggest one that you're going to see is non-payment of rent. Typically, they will prove this by having a ledger of some sort. Termination at the end of the lease. This is where you have stayed and your lease is over and the landlord has terminated the lease. This is not a month-to-month scenario. This is your lease ended in July. It's September. You're still here and you won't leave. And again, what they will typically show is the lease saying that the lease ended, and then a letter from the landlord saying, you know, we have not agreed to extend your lease. You need to leave. They have to give you proper notice, which is what we just talked about. This is the notice to vacate, either 1 day or 3 day or 30 day, right? Make sure you check your lease and check to see if it's a CARES Act property. And the defendant had to have refused to leave. So check the date the eviction lawsuit was filed. So did the defendant leave before they filed the lawsuit? Was the notice to vacate improper? Did they say they would give you 3 days and they really only gave you 2 days before they filed that eviction? For non-payment of rent, the landlord can claim that you owe rent. So they can say, not only have you not left, you also haven't paid rent for 3 days, and they can add for that rent to be paid. The landlord can only ask for rent. So if you owe 3 months of rent at $1,000, they can say you owe $3,000. Any of those late fees or charges, utilities, anything like that, they will have to sue you in a separate lawsuit. It's not proper to be part of the eviction. And either party has the right to ask for a jury. You have to make a jury demand, and there is a fee. In Justice Court, which is the Justice of the Peace Court, the JP Court, all evictions start in the Justice Court. JP courts have exclusive jurisdiction of evictions, which means you have to file your eviction there. Your eviction will be filed in the Justice Court where the complex is located. So if you live downtown, that is in Precinct 1. Okay, so the Harris County is broken up into precincts, and your eviction will be filed in the precinct where you live. They have simplified procedural rules. They do not follow the rules of evidence. And so their processes and their procedures can differ from court to court. Make sure you come on time and you have everything that you need for trial. Some courts will call dockets, while others will have you check in with the clerk. There's no way that you're going to know which is which. So we recommend that when you get to the courthouse and the courthouse opens up, you just walk up to the front where there will typically be a clerk sitting next to the judge's bench. You say, I'm here for eviction at 8 o'clock, and they'll either tell you, go check in outside, or we're going to call you back later, or they'll mark you off and they'll mark you here and tell you to go and sit down until your case is called. Some judges give instructions on how the courts work prior to the case is going to trial. Make sure you listen to those instructions. Judges generally begin by hearing the plaintiff's case first, and then they will give you the opportunity to respond. So make sure that you can answer the judge's questions and make sure you have evidence of your defenses. Trial can be reset by motion of the plaintiff if both parties agree. So if the plaintiff, your landlord, asks for a continuance, typically it's always up to the judge. And sometimes that'll be granted and sometimes it won't, but parties have to agree. If you object and you say, I'm ready to go forward, typically the case will go forward. At the end of the trial, the judge will issue a judgment or will dismiss the case. So somebody will win, somebody will lose, or the case will get dismissed, and it can get dismissed for lots of reasons. Nobody showed up. Like if the defendant didn't show up, if the landlord doesn't show up, probably the case is going to get dismissed. Always get a copy of the judgment and review it for your files. Harris County Justice of the Peace court dockets are available for free online. It's called the Odyssey portal, but you can Google it and you can actually put in your case number and you'd be able to find pleadings for your case. Just as a practice tip, always be respectful to the judge, the court staff, and the opposing party. Settlement agreements. Some judges will encourage settlement agreements for the parties or will provide resources to help you facilitate. So sometimes there's forms and sometimes there's mediators. Whether or not you settle is always up to you. Whether or not you choose to mediate is always up to you. Sometimes it's a really great tool. If there's just one little sticking point you and the landlord can't get past, sometimes a mediator can help you get past that sticking point. Sometimes the relationship between the two people have disintegrated so much that they're talking past each other, that a mediator can help them kind of talk to each other. Settlement agreements require both parties to agree to specific terms, although the parties determine what those terms are going to be. The agreement should be very clear. It should be very specific. It should be things that you can do. Settlement agreements should not be aspirational. Make sure that if you agree to do something that you can actually do it. Settlement agreements need to be in writing and they're signed by both parties and they are filed with the court, okay? A settlement agreement can involve somebody giving up rights. So it might be that you and the landlord agree, I will move out in a week, but in return, you're not going to ask for this month of rent that I'm behind, right? So you're giving up your rights to appeal, for example, and the landlord is giving up some rent. Or I'm going to move out and I'm going to clean up the property and I'm going to do that and you're not going to charge me a different fee. Or even I'm going to move out by this time and landlord, who really wants the tenant to be gone might say, if you really do move out by this time, I'm willing to give you $200 or $300. Every situation is different. Every circumstances are different. But just make sure the agreement is very, very clear. Everybody has the same understanding. The terms are very specific with very identifiable, concrete goals. Nothing should be wishy-washy. And make sure that what you agree to is something that you can actually do. The appeals process. If you lose in Justice of the Peace Court, you have 5 days to file what's called an inability to afford the court costs and fees form, the IFP. You can get it from the clerk. Okay, you fill it out completely. It's under oath and you return it to the clerk. And again, you have to do this within 5 days of your court date. If you don't appeal in 5 days, the writ of possession can be issued. The writ of possession is what gives the constable the right to show up at the complex and forcibly remove you and all of your belongings out of the unit. Within 5 days of filing the IFP, if you're being evicted because you didn't pay rent, you also have to pay 1 month of rent into the court's registry. Your case then gets transferred to the county court at law and is assigned to a court, and you will get paperwork from the county court in your mail, so make sure you check it. Filing your IFP is filing the answer. So you might get a letter from the county court that says you have to file an answer. Your IFP document will count as that answer. If you file your appeal with an IFP and you're being evicted because you didn't pay the rent, not only is rent due 5 days after you file that IFP, rent is then also due as it regularly becomes due. So for example, let's suppose you were evicted last week and your appeal deadline is today, right? You file your appeal today, the 17th. Your first payment of rent, right, 5 days after today is going to be next Monday, because you don't count weekends. If your 5 day falls on a Saturday or Sunday, it carries over to the next Monday. So on Monday, the 23rd, your rent would be due the 5 days after you file the form. So you file the form today, 5 days later, you have to pay rent. But then rent is also due as it regularly becomes due. Well, rent is due on the 1st. So that would mean that you have to pay rent again on October 1st. And if you are still in county court in November, then you would have to pay rent again on November 1st. If you don't pay the rent, you can lose possession of the unit. The opposing party can file what's called a default. And the county court can rule that you have to leave the apartment. But that doesn't mean that your case will get kicked out of court. It just means that possession of the unit will stop. So the case is heard de novo in county court from the beginning, from scratch. County courts are formal courts, so the formal rules of evidence and the formal rules of civil procedure will apply. Justice of the Peace courts are not courts of record. So what happened last time, or what they said in the justice court, or that's not what they told me before, doesn't matter. You are starting from scratch. However, if you are in justice court, pay attention to what your plaintiff is doing, what the landlord is doing, because they're going to likely try some version of that again in the county court, so you can be better prepared. In county court, the landlord has to prove up their case with testimony and evidence. If you lose in county court, you have 10 days to pay the appeal bond. However, the writ of possession can still issue in 5 days. The cost of an appeal bond is usually 10 times the monthly rent, due in a lump sum. And if you don't get your monthly payments set up, some courts will allow for an immediate writ of possession. If you lose in county court, you are actually appealing to the Court of Appeals. In Harris County, that's either the 1st or the 14th Court of Appeals. There are some special cases. These are public housing and subsidized housing. These are also going to be places where we talked about the CARES Act, where you get 30 days and a notice to vacate. So typically this is Section 8, this is low income tax credits, or this is actual public housing. Make sure you pull the HAP contract. So there is going to be not just your lease agreement, but there's also going to be an agreement between the housing authority and the complex. So make sure you pull that as well, because that HAP contract will have very specific things that the landlord has to do. If you are on public housing, you typically have a section that is your part of the rent. So the housing authority might pay $800. Your portion might be $200 for a total rent of $1,000. Well, you are only responsible for paying your portion of the rent, the $200. When you get evicted, the landlord is supposed to put on the petition whether or not part of the rent is paid by a government agency. And if you have to appeal because of a non-payment of rent issue, you are only responsible for paying your section of the rent. So in that example I gave you, it would be the $200. So the tenant protections and the terms are different depending on the kind of subsidized housing you are on. So make sure that you are looking at your lease, that you're looking at the HAP contract, and if you can, seek legal assistance. All right, what else can happen if the lease is breached? Lockouts. Your landlord does have the right to do a very temporary lockout. They cannot permanently lock you out unless they are actually doing bona fide repairs, construction, or an emergency, unless they are removing contents that are abandoned by a tenant, unless the tenant is behind on rent, the right to change the locks is in the lease, and the tenant has been given notice. We'll talk about lockouts a little bit more in a second. And there is a judicial process as well. Utility shutoffs, again, your landlord cannot interrupt your utility services unless there's bona fide repairs, construction, or an emergency, or the shutoff is authorized under the Property Code 92008. As a general rule, just as a blanket rule, if they're going to lock you out, they have to give you notice, which we'll talk about in a minute. And as a general rule, they're not supposed to turn off your utilities. Lockouts and utilities. Even if you're behind on your rent, if your landlord locks you out, they have to give you notice prior to the lockout. If your landlord cuts off your utilities, you can file what's called a writ of restoration. Okay, so we're going to talk about these a little bit more. In order to file these lawsuits, if you can't pay the court costs, you can use that same inability to afford court cost packet that we talked about with appealing evictions to file these lawsuits. All right, once you've been locked out, you should have gotten a notice that says, this is where you can call me or agent 24 hours a day, and someone will answer the phone, and someone will come back within 2 hours and let you in, regardless of the time of day. And they cannot demand payment. The purpose of the lockout, the reason for a lockout is to get the attention of a tenant who is sneaking in and out of the complex and avoiding the landlord, right? So if I lock the door and I change the locks, you have to call me to get back in. And when you call me to get back in, we can have all of those discussions that you've been avoiding by sneaking in and out of the apartment. If, however, your landlord fails to let you in and you're still locked out, you can file what is called a writ of restoration. You file it under oath. It is set for ex parte, meaning it's just you. Your landlord probably will not be there. If the judge agrees that you were locked out, you will get what is called a writ of reentry, which orders your landlord to let you back in. And then you serve that writ of reentry on your landlord. For an illegal lockout, you can get damages. You can get 1 month of rent plus $1,000 of actual damages or expenses, court costs, and attorney fees, minus any delinquent rent or other sums. So if the landlord doesn't do this exactly right, it might be that the amount of money that you owe them for not paying rent was just wiped out by the amount of money they owe you for illegally locking you out. There is also an option to terminate the lease. When the utilities have been cut off, it is essentially the same process. You're filing what's called a writ of restoration. It's an ex parte hearing. So again, your landlord isn't going to be there. You will get what's called a writ of restoration, which orders your landlord to turn the utilities back on. You can get actual damage, a month of rent, plus $1,000, attorney's fees and court costs, minus any delinquent rent or other sums that you owe the landlord. So again, the landlord illegally cuts off your utilities. They might have just given you $1,000 that will wash out the money that you owe them. Security deposits are a separate issue. They're in Chapter 92, Subchapter C. Your landlord can keep and deduct your security deposit for damages and charges for which you are legally liable under the lease or for a breach of the lease. So if somebody got mad and punched a hole in the wall, your landlord can use your security deposit to repair that hole in the wall. Your landlord has an obligation to refund the security deposit before the 30th day after you leave. They cannot deduct normal wear and tear. So if you see that in your itemized bill, normal wear and tear, you need to ask them about that because they're not allowed to do that. If they are keeping any of the security deposit, they have to send you a written description. And in order to get your security deposit, your landlord has to have your forwarding address and you need to give it to them in writing. So before any of this even starts, you need to make sure your landlord has your new address. Other tips: get ahead of the problem. This is a big one. Talk to your landlord as soon as an issue arises. As soon as you can, talk to them. Depending on the circumstances, depending on how long you've been there, depending on your rental history, depending on lots of things, they might be willing to work with you. If you've been a really great tenant for 3 years and this is the first time that you're going to be late, but you're not going to be completely late, right? You get paid next week and you can make up the rest of the difference. They might be willing to work with you. You need to ask them. Rental assistance may be available in your area, so check local organizations. Funding comes and goes. Do not assume that just because you had the place that you called last month has no rental assistance, that they still have no rental assistance. Check again. Funding comes and goes. If you're having issues with the condition of your unit, pay your rent, then ask somebody for help. This goes back to what we talked about before. As soon as you stop paying rent, your rights in Texas pretty much go away. You must pay your rent. Okay. And these are some online resources. I'm obviously not Benjamin Daly either, but if you have any questions, you can email him. Here's his email address. Here's our phone numbers and our website if you would like to apply.
Hey, I don't see, I'm going back to the chat here. I don't see anything in the chat. I did have a question for you though, while I'm pulling up the Facebook and the Instagram. Because people are dealing now with, the aftermath of the hurricane and things like that. If you've got a landlord that has not repaired or basically almost refuses to repair like a leak or mold or something like that, what is a tenant to do if they choose to remedy that themselves when they're not getting a response from a landlord?
So the code is very specific in the kind of things you have to do. You have to send certified notice to your landlord. You have to say, dear landlord, there's a leak in the unit, there's mold in the unit. I've contacted a contractor, it's going to cost X amount of dollars. You have to give them a reasonable time to respond, which is typically 7 days. I always recommend sending a second certified letter to the landlord saying, dear landlord, you haven't responded. This is my second letter. Here's the estimate. It's going to cost this much money to repair this. and then say, if you don't come repair this, I will be deducting this from my rent, and then wait another 7 days. I also, in any instances at all where there's anything having to do with health, mold is a big one, right? Mold is never, I don't want to say never, but mold is almost never just in your unit. If you have mold, there's a halfway decent chance that it's in the vents, that it's in the walls, that it's in your neighbor's unit, that it's in the ceiling, right? So depending on how big the complex is, depending on where the leak is, I would also call the health department and ask for an inspection. Because if the health department comes out and says, yeah, this is mold, they will make the landlord fix it.
Does it cost them to have to arrange to have the health department to come and fix it?
It does not.
And what's the protective measure for repercussions if a tenant was to do that and a landlord then says, hey, you're causing problems, you're causing trouble or whatever, I want you out, I want you gone?
Any eviction filed within 6 months of any kind of repair request is presumed to be retaliation, which is against the statute.
Mm-hmm. Good. Okay, good to know. Let me see here. What are the rights without a written agreement or a contract? If there is no written lease and if it's a verbal.
Whatever you agreed to verbally, which is why it's so important to put something in writing. The things that are covered in the property code that we talked about, like the notice to vacate being required, the statutory protections if you're a victim of domestic violence or a victim of stalking, how the notice is delivered, those things are in the property code. And so they exist whether or not you have a written lease. But things like how much rent is, when the rent is due, can I pay half of my rent on the 1st and half of my rent on the 15th? All of those things without a written agreement, it's basically your word versus your landlord's word.
Okay. This one I'll send to Kimberly directly because this one's very specific. It's got something to do with their child support case and so on and so forth. So this one's very long. So I'll
Okay.
send that one to her directly. What right does someone have that has been incarcerated but not being evicted and rent is not late with no issues on behalf of the incarcerated person and they wanting them to move out?
As long as there's a signed lease, the lease is what controls.
So that's the other thing. I had heard at one point that they were trying to change some kind of legislation for folks that have like a criminal background, since it is hard for them to find adequate, affordable housing with a rental, with a felony conviction. How far back are they then still allowed to go when it comes to, I mean, because I know people that have felony convictions from 15, 20 years ago, and sometimes landlords will still hold that against them.
I am not aware of there being any kind of cutoff. I think under federal programs are not supposed to go back more than 10 years, but don't hold me to that. I think that's what they were looking at changing. Yeah, so I might not be getting that right. I know for federal programs, when you apply, you have to tell the landlord if you've been convicted of a felony. And if you lied on that application, then they can evict you for lying on the application. But if they told you, hey, I was convicted of a felony 8 years ago, and then they want to evict you after you disclosed it and then you signed the lease, they can't then say, oh, but you're a felon, right? Because you told them you were a felon.
What if there's a change in the management company? Like if one property management company has a policy that, they'll accept it, and then a new property management company comes in and it's time for the renewal. Now,
Well,
can they give you that reason?
Yes, when it's time for a renewal, they do not have to renew your lease. They can't terminate your lease. They have to take what they got when they got it. But when it's time to renew, this is why you will see rents going up when people renew their leases. This is why you'll see changes in policies when people renew their leases, because it's a new contract.
Do they then have to give you the reason or the new lease in writing though, or it's just?
Yeah.
Okay.
Yeah. And you can agree to it or not agree to it. And if you don't agree to it, then you have to move out.
Gotcha. So I'm assuming this question was about not having a lease. Do these same rights still apply without a written agreement between a tenant and a homeowner?
The same rights that are in the statute apply in any kind of landlord-tenant relationship.
Okay.
The issues about not having a written lease also apply in any kind of landlord-tenant relationship. The terms are, it's going to be his word or her word, it's just he said, she said, right? If it's an all oral, except for things that are in the statute. Those are required by the statute.
Gotcha. This one says, so let's say the landlord breaches something on the contract. I still have to pay rent, even if they breach first, or can I sue later for the breaching of the contract and by continuing to pay the rent that secures me until the end of the contract?
If you don't pay your rent, they will evict you. It doesn't matter what they have done. You always, they are separate and independent covenants. That's the legal word for it. You are never excused from not paying rent. You can then, if they are also doing other things, turn around and sue them for those other things. But you can't just stop paying your rent.
Like, so just general specific questions on mine. What if it's a breach for never fixing appliances or saying that they have security and there's no security? So basically, when they have promised an amenity or something in your agreement, but it's not actually being provided.
So you would have to double check your lease and see what rights the landlord has to change amenities without letting you know. Some things are material, some things are not. So if it's a material item, like, I don't even know. I think a refrigerator probably would be material, right? Like a stove. And then they try to give you a unit that doesn't have those things. I think you can say, no, that's not okay. Security probably is material. But it would need to be in your lease. It would need to be something that says these are things we are going to provide you. If it's a pool, I don't know that a court would consider a swimming pool to be material, right? Like, what does that really have to do with your health, safety, and welfare? It's a swimming pool. Now, if they're charging you a fee for the swimming pool, that might be something different. So there's a whole bunch of kind of nuances, but essentially it's going to boil down to what's in your lease. What does the landlord say in the lease agreement that you signed in your contract that they're going to provide you? And then what are they not doing? But you are never excused from not paying your rent.
Okay. The landlord / homeowner is going through a divorce and they both own the home. Without a written agreement between the homeowner and the tenant, do both homeowners have to agree on the eviction?
Without a written agreement, you're typically in a month-to-month agreement. And then both owners have to. That's interesting. Actually, I'm not sure I know the answer to that one.
That's a new question for me too. I haven't
It's a new question. If it's two people that own the home together, they're renting it out to somebody, and one of them wants to evict the person and the other one doesn't. But there's no lease agreement. That's the problem. That's the problem you have, is there's no lease agreement. So I would argue that both parties do have to agree to lease to somebody, right? If I own a home with someone else, they can't lease it to someone unless I agree to let them lease it to someone. So I think the answer is yes, one person can evict you.
Okay. That's it for the questions that are in the chat. Let's see. Yeah, that's all I've got there. I don't see anything on Facebook or social media either. I did have another question. So she says it's more of a family member to try to remove another family member from the home.
So I feel like we're kind of wading into specifics now, and it might be at the point where you might need to reach out for legal advice.
Yeah, I definitely agree with that. Question in regards to, and I know everybody now has emotional support animals or and not necessarily service animals. What's the law there as it relates to emotional support versus
The
service
the law
animals?
is kind of murky. Service animals for sure are covered under the ADA. That's not a question. Emotional support animals, I think you can make the argument they are covered if they are tied to a diagnosed condition. So just hypothetically, let's suppose you have severe anxiety and your psychiatrist has prescribed an emotional support animal. I do think that would be covered because the underlying condition is covered. So it's a little, I think there's kind of more steps to get there. You might have to, get a note from your doctor saying, I require this. But it's more of a gray area. I think there is some updated guidance on emotional support animals, but I think it does require kind of that extra step.
And then as a tenant, what are they supposed to be required to provide if asked, or so that they'll know, oh no, landlord's not supposed to ask me for this. I'm supposed to be able to provide you this without violating their privacy.
So you would do a reasonable accommodation letter to your landlord saying, I have a condition covered by the American with Disabilities Act. I require the emotional support animal, prescribed to me by my doctor. And I think that's kind of generally it. If the landlord persists, I think you can confidentially tell them what the condition is, right? But typically you just file the letter under the American with Disabilities Act saying I have an emotional disability and I've been diagnosed by a doctor and I'm under the care of a psychiatrist who has prescribed me an emotional support animal.
And it's them, or does that a letter that has to come from their doctor?
It can come from them.
Okay. Let's see what else there. And as far as like security deposits go, are they allowed to or not allowed to charge security deposit or pet rent? Or
They are allowed to charge pet rent.
okay.
Yeah.
That's been I know that there's been a lot of that going on, so I wanted to make sure that got covered. Let's see.
They're not allowed to keep you from having the animal. Right. So if the extra cost of the pet rent is a burden, that might be something that you can negotiate under.
Now, what if the pet is against the policy, like a particular breed of animal or something like that for the actual property? Can you then be denied on an
We are
application?
now getting into the weeds on the ADA, and I do not know the answer to that.
Okay. Because I know of someone that just got an emotional support but it is a huge pit bull. So it's like the policy for the property already is no large breed, and there's a particular exclusion of breeds of animals, and they
Yeah,
just
so
got it.
is
Yeah, that's
this is not something I would know the answer to.
okay.
Is Disability Rights Texas one of the partners?
No,
So that would be a good group to refer that person to, Disability Rights Texas.
Disability Rights Texas.
Yeah, they have a Houston office.
Okay. Hopefully by next month, then I'll have the response to that. for those that want to know. Okay, I don't see anything else online, and I don't see anything else in the chat. Oh, Cecile, good question for you. When a property becomes uninhabitable for the city of Houston, if water is not working or AC or something goes, what's considered to be uninhabitable for the city of Houston to then get involved with a repair or something that needs to be done?
I would have to get back to you on that question. It's a little bit out of the scope of what I know, but I can certainly get back to you with that information.
Okay.
I don't know the specifics.
I know that that's a question that generally tends to come up or has come up in the past. When do you call 311 to report something that's now uninhabitable? And from my understanding, I know that after a violation or something has been issued, that the landlord only has so many days or so much time to actually get it remedied. Otherwise, the tenant has to move, and then they can no longer then rent the property out until it does become remedied. The specifics about that, I'm not for certain. So that I was just asking the question, trying to think of something that most people here actually ask questions about. Okay, I believe that is all that we have, ladies and gentlemen. I don't see anything else in there in the chat. Is there anything else that you'd like to add or to kind of conclude, Sapna, while we wrap up?
Just the one big takeaway, if you learn nothing else from this presentation, pay your rent. If you learn nothing else, pay your rent.
And don't wait till the last minute.
And don't wait till the last minute to talk to your landlord. Try to figure it out.
Landlords. Most definitely talk to the landlord. And because otherwise if you lost a job or you're going through a financial discourse or something, they don't know that you need help if you're just not talking to them. Otherwise, how they say, closed mouth don't get fed. If you don't ask, then nobody knows to actually provide you with any kind of assistance. You can't just keep it to yourself. So don't let your pride get you evicted. And another person says, document, document, document. Yes. Definitely cover your selves. That's what I will say. Let's see, what do we got coming up tomorrow? For a month of service, we have the maintaining and adding value to your home. So we'll have some home maintenance tips, even for those folks that live in an apartment. If you want to know some basic things about, how to identify when you've got mold or changing filters and when things need to be done in your unit, that's probably a good workshop for you to actually attend to, especially with disasters and things like that going on. And then we have Coffee and Conversation that's coming up on Tuesday, the 24th at the Sunnyside Multi-Service Center. Feel free to come by and join the month of service partners. If you've got questions about any legal documents that you'd like to have reviewed, if you've got questions about some title issue, if you've got questions about something related to your property taxes, this is being an opportunity for you to come in for a Q&A session and to get a little bit more information about what each of the a month of service partners actually provide. So Cecile, do you want to say anything else about that?
Yes, thank you so much to everybody that logged on. Thank you to Lone Star Legal Services. Sapna, thank you so much for that information. Certainly learned a lot. Pay your rent for sure is the big takeaway. And just want to thank everybody, all the partners, and looking forward to tomorrow's conversation. And I will try to get that answer for you because now I'm curious too about when does the city indeed intervene. So thank you so much.
Okay. All right. With that being said, thank you everyone for joining us this afternoon. We will relinquish the remainder of your time back to you. I hope that you guys received all the information that it is that you needed to help empower yourself when it comes to your rights as a tenant, what the process is for eviction, and where do you go for assistance if you do find yourselves in need. In addition to that, as we mentioned before, that the session is being recorded. I will be sending out a link for everyone to go back back to review it in case they would like to go back and review some of the information that was presented, as well as the resources for some of the legal service partners for you to reach out to in case you do, again, would like to apply for the service. So I will also include the schedule for the remainder of the month so that you can get a general idea of other workshops that we do offer throughout the month. There's a little survey link that pops up at the end of the presentation. So if there's something that we don't currently offer that you may be interested in, then please feel free to reach out to myself or Cecile and say, hey, have you guys ever thought about such and such or whatever? Or this is a big topic that's going on in my neighborhood or in my community right now. Can you address these kinds of things? Then please feel free to reach out to us and let us know as we're planning for the fall and also for the first of the year. Then we can see what we can do about incorporating that into future presentations as well. So, and plus we'd also just love to have your feedback on the information that we do provide, if, if it's helpful, if it's not helpful, and, things of that nature. So, Sapna, thank you for filling in for your cohorts. We appreciate your time. Miss Cecile, thank you and welcome to the A Month of Service collaboration, as you will be our new spokesperson for the City of Houston's Department of Neighborhoods. So we want to welcome you aboard officially and thank you for being here this afternoon on behalf of the entire collaboration. You all have a wonderful day, a wonderful remainder of your afternoon, and we will see you all next time.
Thank you so much.
All right, thank you.